preparing your declaration, written statement, whether it's for asylum case or a waiver case, any kind of immigration case, most of the time you will have to write some kind of statement. That includes even just changing your status. For example, if you're a student in the United States, or if you're applying for a student status, you're here maybe on J1 visa or whatever it might be as a visitor, you're filing for change of status to student status, you can, you will have to write some kind of written statement. Now, it applies a lot to the asylum cases. So in asylum cases, you must provide a written statement. And that written statement has to be more thorough, more detailed, and it has more weight and more importance for asylum case. But again, as I said, it applies to any cases. Anytime you file a form with the USCIS, as supporting documentation, I recommend including a written statement explaining or expressing your thoughts or reasonings why you need to change status or do whatever you need to do. Whether it's a waiver that you're applying for, you need to make a statement. So when I talk about preparing written statements, when I talk about preparing witness statements, this refers to every type of case, not just asylum, okay? So you can apply it in asylum case or any other case. Now, witness statements are also important. Even in a marriage-based case, for example, if you're filing for a green card based on family reunification, then you want to provide some sworn statements or affidavits from friends, relatives, landlord, acquaintances, from someone who knows you and your spouse, who will be confirming that this is a legitimate marriage. So in those cases, the written statements are important as well. So I have a cheat sheet that I make and I share with my clients. So what I will do is I will share that information with you. I'll tell you what I tell my clients when they are preparing their written statements, their declarations, and witness statements and witness affidavits, what is important to know. So preparing a written statement is an art. It's important. It's important because your written statement is not just a check mark for you that you have to do it, you have to write something and provide. It's actually important step, important proof in your case. The written statement in asylum case provides two important roles. One is plays two important roles, and one is you're giving a summary of your case. You're giving information to the reader so that they know what this case is about. Second, you're providing the details of events and everything you're describing sufficient enough for that adjudicator, whether it's asylum officer or judge, to be able to question the veracity, the truthfulness of the information you're going to give them at the interview or at the immigration court. So, I see sometimes people think that there's applicants, trying to be smart and prepare a one-paragraph summary written statement so that the government attorney in immigration court or the asylum officer doesn't have enough tools or ability to question and compare your oral answers during your interview or hearing with your written statement. That doesn't help. That hurts your case. By limiting their ability to question you, you are, disserving the court, you're disserving the asylum office, and they're not happy about it. So, this is going to be a big minus in your case. So don't try to, outsmart them by providing generalized statement, generalized words. So what you have to do is you need to make sure that it's easily readable, that is simple, using simple language. It gives the reader information immediately about your case, the context of your case, the information about what your case is about, so the reader can quickly and easily understand it from the first maybe couple paragraphs. And then it gives enough details so that you cannot be questioned about the lack of details in your case, all right? So if you provide incomplete written statement, if you don't provide enough details, the government attorney, the prosecutor in immigration court, is going to use that as an argument against you. And every single judge, no matter how liberal, how, the lots of clients call it loyal judges, no matter how loyal they are to immigrants, how so much sympathizing, every single judge is going to hold it against you. Why didn't you put this in your declaration? Why didn't you provide sufficient information? This question will come up. So you want to make sure that your declaration is complete. Now, the more details you provide, the more information you provide, the longer, the more pages will be your written statement, right? And imagine yourself being an immigration judge who has hundreds and maybe thousands of cases, and you don't have enough time. You have hearings. Some immigration judges have like two or at least two, but sometimes they have three. I don't know if they have four individual hearings, trials per day, because they're being pushed by the Attorney General to get these cases decided much faster. So they don't have enough time to read your 20-page declaration, right? But some do, but most of the judges, unfortunately, don't have enough time to be able to read your entire declaration. A lot of times, the judges actually tell me at the hearing that, counsel, I'll tell you honestly, I didn't have a chance, or I wasn't able, I'm not going to read the 20 pages of the declaration. But the government attorneys do, not all of them. The prosecutors do. The asylum officers, they often don't. Sometimes I've seen asylum officers come to the asylum interview and they don't know anything about your case, right? So that happens rarely. That's very bad. They're basically trying to interview you and then take the notes and then read your story. And that's why a lot of times asylum cases get stuck even after the interview for a long time, because the officer takes forever to then read. And, when they see a 20-page written statement, they kind of, they feel a little bit, hesitant because it's too much. They have other cases which have 2-page statements. So they prefer to do that. It's just a human nature, any kind of work, anybody who works. I don't believe there is anybody who's doing work and they get excited that, I have a 20-page instructions to read. Or when you open, a product you bought and you get a book of manual to read, nobody gets excited about that. So this is their work and they don't get excited. So your goal is to make it as simple, as pleasant, as easily readable for them as possible. And how do you do that? So one of the important steps is to summarize the entire declaration in the first 1 or 2 paragraphs, right? So you start your declaration. You don't have to do any, what we say, throat cleaning. Like you don't have to say things that are redundant, are irrelevant, reciting your name, address, place of birth. This is all in your form. You're filing your form I-589. It has all the information, right? So don't do that. So, again, for anybody who's listening, maybe you have some immigration question and you're trying to, join this live stream to ask that question. That's great. Post your question in the chat section, or you want to listen to other questions and so on. Don't skip this part. No matter what immigration benefit you're applying for, no matter what, well, it's a visitor visa you're applying for, right? For example, you're abroad, you want to get a visitor visa, student visa, you want to come through CBP1, enter US, apply for asylum. No matter what you're applying, this topic is relevant to you. So don't try to skip it. It's very important. I'm just trying to help you. I don't care if somebody skips it, but I care about you. I want to make sure that your case is good and that you have the maximum chances of winning whatever you're winning, whether it's a visitor visa approval or asylum approval. All right. So the tool, as I said, the first recommendation is make a summary statement in the first 1 or 2 paragraphs, summarizing what your case is about. I'll give you an example. Don't use my words because your case has different facts, right? So it could be starting something like this. My name is Ismail Shahtartinsky. Let's say if I'm the one. Well, I'll use something else. My name is John Smith, and I'm applying for asylum. I'm asking for protection in the United States because I'm afraid or I cannot return to my country. I have been arrested, I've been beaten, I've been tortured, I've been charged with crimes, with bogus crimes, and there is an open bogus criminal case against me in my country. If I return, my family and I, have been threatened, and that's why I cannot return to my country. That's why I'm asking protection in the United States. So this is one paragraph, about 4 sentences here, but if you can make it into 3, the less the better. That first paragraph, okay, we're going to continue breaking down everything that I said, but in the first 1 or 2 paragraphs, I gave the full summary of what this case is about. Oh, one thing I missed, one other sentence there is, I've been arrested, tortured, beaten, or so on because of my distributing religious materials or religious books, because I'm promoting, whatever religion, or because of my ethnic origin, ethnicity, ethnic origin, or it could be, you could say, if it's political opinion, is because, because I refuse to follow the orders of the government officials. Maybe you may be a businessman who refused to obey the orders, or you refuse to, join the monopoly in your country of the government, or you refuse to, join some corrupt schemes in your government job, whatever you did there. So make that one other sentence about the basis of your claim, the category, whether it's political opinion, religious based, nationality, race, or membership in a particular social group. Or so in that first 1 or 2, maximum 2 paragraphs, which consist of maximum 3-4 sentences, you want to give the full information in form of summary to the reader what your case is about. An immigration judge or asylum officer can read that 1 or 2 paragraphs, and they can have the full information they need to be able to question you. Now, if they want to go into the details of your case and then test you at your interview or hearing about the consistency and knowledge of what was written, and they have to, that's one of the instructions they get. They have to ask you questions, then verify that everything matches. They have their tricks, how they ask these questions, and then, lead you into believing that you have to answer it one way or another, and then boom, it's inconsistent with what you wrote there. So you want to give that to them. You want to prepare very detailed follow-up after these first 1 or 2 paragraphs, so that in that breakdown, you write about those things. Because in the first paragraph, you said, you've been arrested and charged with bogus crimes because you criticize the government, right? So now in the following paragraphs, you want to break it down, how this happened, who arrested you, where they came, where were you at the time, how many people came, what was the process, they took you to where, to police station, they charged you, what is the bogus crime they charged you with. So you want to give all of those detailed facts after the summary. Don't start with a romantic story about your life. I was born, blah, blah, blah. I went to school in blah, blah, blah. I did this. Nobody cares. I know it sounds rude or maybe, counterintuitive, but an immigration judge or immigration officer, they don't care about anything that doesn't have, factual influence on their decisions. So nobody cares about your life story. Nobody cares about, just be called straight to the facts. Yeah, again, we're talking about in your declaration. And so the summary paragraphs in all the written statements, declarations is important. Neither the judge nor officer is going to read, most likely, the whole 20 pages of your declaration. One of the questions I get asked, how many pages should the declaration or written statement be? There is no limit. There is no specific length. I've had cases where we had 1-page written statement because something concrete happened to a client of mine. This was one incident, one event, but that was enough for them to qualify for asylum. I've had cases where we had 20-page declaration, literally 20-page declaration. And, again, don't ever do that. Don't ever send a 20-page declaration without having a summary in the beginning first 2 paragraphs. So what is the other tool to make it easily understandable, readable, and quickly understandable by the judge or asylum officer? It is to use simple language. I always tell my clients, when you're in immigration court or when you're talking to an asylum officer, you're answering questions, not only to the asylum officer, but any kind of officer, immigration officer, use simple language. Talk to them like you would talk to somebody who is not a government official, who's not an officer, who's not a judge. I'm not saying disrespect. You still should say your honor to the judge or judge, but I'm saying in the language that you use, the simplicity of the words. Don't use legal terms. Don't use complicated terms. Don't use, eloquent, archaic English language that a lot of lawyers try to use to impress their clients. You see sometimes lawyers make these contracts. When I started my practice about 16, 17 years ago, I became a lawyer. That was the first thing I told myself. I said, screw this. Why do these lawyers have these long pages? Looks like the king's messenger would come, they would open these long pages. There are still lawyers that use these what's called legal size pages, where nobody actually needs that, and it doesn't fit anywhere. The courts hate it, the clients hate it, everybody hates it, but they do that to impress the client, like this is something you wouldn't understand. We lawyers only deal. Or they use these ancient 15th century English language. You've seen that in the contract, witness if, thereby, herein, and all that stuff. Don't do it, okay? So the bottom line is don't do it. And this is not for me to educate the lawyers to cut that crap and just be normal, down to earth people. But this is for you. So this is for you, and you should cut that crap and don't use any legal language in your declaration and statements. Talk simple, write simple, use simple words, use smaller sentences. So a lot of immigrants come from countries where complicated language is encouraged. I mean, unfortunately, I grew up during the Soviet Union time in Azerbaijan, and I went to school in Russian language, and then we switched to Azerbaijani once the Soviet Union collapsed. I've been in the US for the last 23 years, but I grew up, I went to basically high school, up to high school, and then college in Azerbaijan. And there, unfortunately, in those countries, and a lot of post-Soviet countries, they encourage these long, complicated sounding sentences. It's just, a lot of these governments are autocratic, bureaucratic. They want to complicate things for regular citizens so that they can ask for bribes and payments to be able to do, or make things look very complicated for a regular person so that they end up paying money instead of getting this thing. But that's not the case in the United States. And that's why you want to move to the US, or you are already in the United States. That's one of the reasons, is because this is not the same type of country. So, and that's why you have to adjust your language. Sometimes I see documents from foreign countries, from mostly of the third world countries, and it's one page, one sentence covering the entire page. It's a document, official document, some criminal, I don't know, whatever that is, a request or so on. So yeah, that don't do that. Use simple language. Now there are terms, there are specific words that you can use in the summary paragraph, but when you go in to follow up with the details of your case, you want to expand those words. You even want to avoid. I mean, one word that I wouldn't use even in the summary paragraph of your declaration or statement is the word persecution. And I see that a lot. People try to squeeze this in their written statement. If I go back, I will be persecuted, or I was subject to persecution. Don't do it. Persecution is a legal conclusion to which the immigration judge or immigration officer has to arrive to grant your asylum. So if you are throwing the word persecution, first, it's too general. There is no factual definition of what persecution means. Second, you're just putting words into their mouth that, oh, I've been persecuted. That means, don't even try to decide my case. I'm telling you, I was persecuted. Give me my damn asylum, and that's it. Let's all get it over with. No, don't do it. You don't want to give the word. You want them to reach that conclusion that, oh, yes, this was a persecution. And you don't want to use that word, okay? Using that word persecution in your asylum claim is absolutely no, unless there are some exceptions. In very rare circumstances, somebody's going to ask you, do you think you will, the officer or so on can say, do you think that you will be persecuted if you go back? You can say, yes, I will be persecuted. But in that case, you should also break down and say, yes, I will be persecuted because I have already been. I've been beaten. I've been threatened. I've been consistently, systematically threatened. I was tortured. I have criminal case against you, bogus charges, and so on. So even if you, for some reason, if somebody corners you, the judge or officer, and forces you to use the word persecution, do that, but get out of it immediately, breaking down for them what you mean by the word persecution. So with that, the same applies to the words threatened, harmed, and pressured, and attacked. Again, in the summary paragraphs, in the first two paragraphs of your written statement, or if you are giving somebody a summary of the reason why you cannot, even if it's oral, you can use those words, but break it down to actual facts as to what happened. Because I was threatened, it may seem to you as a fact, but it's not. It's a conclusion, right? Because what is being threatened? How do you threaten someone? So instead of saying I was threatened, again, in the first two paragraphs where you are giving summary so the reader immediately understands what your case is about, you can use that. I was threatened and I was charged and so on. But when down the road, when you say, they threatened me, say what happened. They told me that they will put me in jail. They told me that my family will be, killed, harmed, or my kids will be kidnapped. Or they took something, they pointed a gun at me. That's a threat, right? So, or somebody raised their hand and said, I'm going to slap you in the face. They didn't, but it was a threat, right? So they raised their hand to slap me. So describe what happened. Don't leave the words threatened without breaking it down in your statement as to what actually happened. Same with harmed. I was harmed. They harmed me. They hurt me. What do you mean hurt you? They hurt your feelings, or did they hurt you physically? Even physically, what is hurting physically? So did they slap you? Did they kick you? Did they stab you with a knife? Did they cut something? I mean, describe, use rough language, use just words, I tell my clients, answer these questions, talk like you're talking to your friend. If you come to the United States and you are in the US, let's say you're going to school, you have a classmate, or you have, a colleague, friend you met here, and he's saying, hey, John, what happened? Why can't you go back to your country? What happened? What will happen to you, in Russia? Let's say you're from Russia and you're Dima, and your friend says, Dima, what happened to you? Why can't you go back to Russia? And you want to say, you're not going to say, if I return to Russia, the government authorities will subject me to persecution and hurt or harm me, right? If you say that, your friend is probably going to stop being your friend, if you talk like this to them. So just like you would tell your friend, hey, I cannot go back because I am against this government, I'm against this war, and I made myself clear. I spoke about this, I made posts about it, and I had somebody come and catch me in the street and they beat the hell out of me. You can leave out the word hell when you talk to the judge, but sometimes it may actually help. So talk natural, right? So simple language. Tell them what happened. Don't say I was harmed. Don't say I was pressured. That's the word I hate. I hate this word. I see lawyers putting that in the declarations. I putting that in the written statements for asylum clients. I was pressured to sign this paper. I was pressured to, participate in this corrupt scheme. I was pressured to leave my country. What is pressure? Like somebody put a machine that is actually pressing down on you. I mean, what the hell is pressure? Say what happened. They told me if I don't sign this paper, they'll plant drugs and they will put me in jail, in prison. And they told me that they'll kidnap my kids from school. They'll do this, they'll rape me, or whatever the pressure that you mean behind the pressure, break it down, give the facts. Again, with the exception that in the beginning of your written statement, in the first two paragraphs, within 3-4 sentences, you want to use these general terms to give the reader the entire context the entire, summary of your case, so that a lazy immigration officer or a lazy judge, not, good to call them lazy, sometimes they're just overwhelmed, not to blame them. The judge that doesn't have enough time, or the officer doesn't have enough time, that can only read these 1 or 2 paragraphs out of your 20 pages, they know what the case is about. Okay, so that's important. Now, the third rule that I tell my clients that are working on their written statement, that we're working with them on, is to include all of the incidents and events, right? So all of the incidents and events that can remotely have effect on your case. Now, obviously the point of having a lawyer is that you're going to describe those things, and the lawyer is going to decide, oh, maybe that's not even important. You were walking down the street and somebody yelled a slur at you, some ethnic slur, right? Maybe I'm going to exclude that from the case. Why should we distract the attention? Then the government attorney is going to use this and say, oh, he wants to apply for asylum. He wants asylum because somebody yelled an ethnic slur. So sometimes you don't, but give it to your lawyer. Let your lawyer know, so that your lawyer makes that decision. The worst thing can happen is you have an immigration court hearing and the government attorney asks you questions. Has anything else happened to you? Have you been threatened, in your country? And you tell them what happened, and they're like, oh, but why didn't you put that in your declaration? Why are you just telling it to me now? Now, you may have a good explanation. Why didn't you put that? Because you didn't think it was important. You didn't think that this was, sufficient incident for your asylum claim, in support of your asylum claim. But even if you gave a good explanation, you are putting yourself in defensive by leaving it out. So to, and excuse my language, to shut up that government attorney, that asylum officer, or the prosecutor in immigration court who's going to use this, oh, why didn't you mention that in your story? You want to put everything in your story, let them have it, let them just be satisfied, so they can not claim that. There are some prosecutors, they'll still find something and they'll say, oh, you were left out of this word, but they're going to make themselves, look funny to the judge if they do pick on the word being left out. So, but if there is an incident, something may seem to you as not that important, but your lawyer and, and the judge may consider that this is important. So talk to your lawyer and make sure that you disclose all of the incidents happened to you that remotely relate to your claim for your asylum, and include that in your declaration. Most likely your lawyer will tell you, let's include it, because the lawyer also wants to make sure that, nothing is left out, and then this becomes an issue. Then you're going to say, oh, my lawyer told me that to exclude it. So disclose all of the information, discuss with your lawyer, all right, whether you should include this or not in your declaration.